Welcome back to the Deep Dive. This is where we take stacks of dense, often overwhelming information and deliver you the precise, high-value insights you need to be immediately fluent in a complex topic.
And today we are doing a highly specialized deep dive. It's tailored specifically for you, a cybersecurity consultant, perhaps like Harshdeep Sharma. We're focusing entirely on information security law and compliance.
Yeah, the legal mandates, these don't just exist alongside your security controls, right?
Yeah.
They actually drive them in many cases.
They absolutely do. And our mission today isn't really to turn you into an attorney. That's not the goal.
No, definitely not.
The mission is critical, though. We want to move past that, compliance checklist mentality.
Right. Just ticking boxes.
Exactly. We're going to pull out those specific, often surprising nuggets of legal knowledge that directly translate into managing organizational risk and, crucially, designing robust technical systems.
So when a new regulation lands, you need to know, okay, what exact configuration change does this demand? Not just that the regulation exists.
That's precisely it. It's the difference between knowing the definition of GDPR, for instance, and knowing exactly how the right to erasure affects your database schema.
Ah, okay. And like your backup retention schedule too.
Yes, precisely. So we've structured this dive to start with the foundational legal categories, like what is the law? And then we'll move pretty quickly into the complex global mandates.
And show how things like due care and due diligence translate directly to the controls you deploy every single day.
Exactly. It's all connected.
Okay, let's unpack this. And I guess we have to start right at the absolute foundation, the actual legal environment we're all operating in. So for Harshdeep or anyone in that consultant role to really understand why we implement complex systems like, logging, retention, or firewalls, we have to grasp the overarching legal landscape first.
We do. Our sources break this down into three sort of essential categories of law that any information security professional really must navigate.
Okay, what's the first one?
We must start with the most serious one, I suppose, which is criminal law. This is really the highest level of legal framework.
Okay.
It outlines the rules and sanctions for major violations of public trust. This is where the government, acting on behalf of the public, pursues action against an individual or an organization.
And in the U.S. context, what's the primary driver of cybersecurity-related criminal law? Is there one main act?
There is. That would be the Computer Fraud and Abuse Act, the CFAA. This is the main tool the government uses to prosecute things like unauthorized access, intentional damage, or theft of information from protected computer systems.
Right. And violations here mean serious consequences, not just fines.
Oh, absolutely. Heavy criminal fines, yes, but also potentially prison time. The real purpose here is, punishment and deterrence of major offenses against the public order.
Okay, so criminal law punishes offenses against the public good. But then the second category is civil law. That feels much more focused on business, doesn't it?
It does, very much so. Civil law provides the essential framework that allows businesses to operate smoothly, manage contracts, interact with each other. It's the structure for business transactions.
And it provides legal recourse when things go wrong.
Exactly. Crucially, it provides legal recourse when obligations aren't met. It governs disputes between individuals or organizations, not necessarily involving the government as the prosecutor.
So things like trademark law, patent law, contract law. If one company sues another over a breach of contract, that's civil law in action.
That's it. And the aim there is usually about making the injured party whole again, maybe through damages, rather than punishing the perpetrator with jail time, like in criminal law.
Okay, got it. Criminal, civil. What's the third one?
And then we move to the third category. This is the one that security professionals and especially consultants like Harshdeep probably engage with the most day-to-day. Administrative law.
Okay, why is administrative law so critical for a consultant specifically?
Well, administrative law is... you could think of it as the operational arm of the government. It's used by government agencies like HHS for HIPAA or the FCC, whichever agency is relevant,
Right.
To interpret, implement, and then promulgate those highly granular day-to-day regulations. You often find these regulations codified in places like the Code of Federal Regulations, the CFR.
Ah, okay. So if Congress passes a big, broad law like IPO,
Yes.
it's the administrative agencies, like HHS, that write the incredibly detailed rules saying exactly how we have to protect PHI.
Down to maybe encryption standards or logging requirements.
That's the hierarchy. Precisely.
Yeah.
And a critical nuance for someone like Harshdeep is that administrative laws and the actions of these government agencies must always comply with existing civil and criminal laws.
Ah, okay. They can't contradict the higher laws. No, they can't implement a regulation that directly contradicts a law passed by Congress, for example. So, if your security control is driven by a requirement you found in the CFR, you know you're dealing with administrative law, which sits beneath those broader civil and criminal umbrellas. Hashtag tag 1.2, the principle of due care and due diligence.
Okay, so moving from the types of law, we need to talk about what leadership, what management has to actually do to protect the organization and, minimize their liability.
Yes, and this brings us to that famous pair of concepts, due diligence and due care. This is really the cornerstone of security governance.
They sound similar. People often mix them up, right?
They do, very often.
Yeah.
But the distinction is absolutely vital, especially if things end up in a court of law. So when we discuss due diligence, we're talking about the effort.
The effort.
Yes, the effort of developing a formalized, planned, structured security environment. This is the intellectual work, the foresight. It's creating the security policy, defining standards, setting baselines, writing procedures. It's the comprehensive strategic plan to protect assets.
Okay, so due diligence is like commissioning a big risk assessment and then drafting detailed patching standards based on what you found. It's the preparation phase.
Exactly, it's the preparation. Whereas due care is the actual action.
Action. Well,
It's the ongoing practice of individual activities that maintain that due diligence effort. It's the continued application of that security structure onto the IT infrastructure day after day.
so if due diligence is writing the patching policy,
Uh-huh.
due care is making sure the patch management team actually does the patching on time every week, like the policy says.
That's the perfect analogy. Diligence is the plan. Care is the execution.
Okay, but wait. What about things like updating or reviewing the policy itself? Is that diligence or care?
Mm-hmm.
Because it feels like maintaining the plan.
That's a really good question, and it highlights the fine line sometimes. Generally, updating the policy, reviewing it periodically, that's seen as an ongoing duty.
Yeah.
So, it falls under due care. Think of due diligence as the initial creation of the security structure. Due care is the ongoing maintenance and execution of that structure, which includes keeping the policies current.
Right. Because if you just write the policy once,
Overlapping,
yeah,
and then never look at it again.
and never audit it or enforce it, that's not enough.
Exactly. That's a lack of care. And that lack of care exposes the organization to legal trouble, specifically negligence.
Ah, okay. That distinction is crucial because it leads directly to the legal implication of negligence for senior management, doesn't it?
It absolutely does. Senior management can be held personally accountable and liable for asset losses if they fail to show, common sense, prudent management, and responsible action.
So they need to demonstrate both.
Both. They have to show due diligence, the planning, and due care, acting reasonably, following through. If they fail on either front, the legal system can view that as negligence.
And the lack of action or unreasonable action is key.
That's the crux of it. If a breach happens and management cannot prove they took reasonable, prudent steps to protect assets, both planning and execution, they could be found liable.
And this whole framework, the planning, the acting, the oversight, that's all wrapped up in the term security governance, right?
Yes, security governance is that high-level method. It's often overseen by a board of directors, and its purpose is to ensure the security program aligns with the overall business mission.
It's not just an IT thing.
Not at all. And what's critical here, something our sources emphasize, is that governance explicitly involves comparing internal processes against external knowledge.
What do you mean by external knowledge?
Well, that's why boards often include people from varied backgrounds and industries. They bring that external, real-world perspective.
So they can ask, are we doing what other reasonable companies in our situation are doing?
Precisely. It helps ensure the organization isn't operating in some kind of security vacuum, that its practices align with broader industry standards and expectations. That comparison is key to good governance. Hashtag 1.3. The role of compliance and external standards.
Okay, so we've got the legal environment, the management obligations of due care and due diligence through governance. Now let's talk about compliance. If due care is about demonstrating prudent action, is compliance just the official external proof of that action?
That's actually a pretty good way to think about the connection between them. Compliance is essentially the mandatory adherence to requirements.
And it's not just laws.
No, that's important. It's not just law and regulation. Compliance includes adherence to industry standards like PCI DSS for payment cards,
Right.
or specific contractual obligations you might find within an SLA, or even licensing requirements for certain software or operations.
So it's a broader set of mandatory rules.
It is, and it's a fundamental concern of security governance. Proving compliance typically requires some kind of outside investigator or auditor verifying that adherence. It's that external validation.
And often these requirements, these compliance needs, are structured and managed using big established frameworks, right, to help organize the due diligence part of the work.
Exactly. There are sophisticated frameworks that help organizations structure their efforts. Two major examples that come up frequently are ISO and COBIT.
Okay, tell us about ISO first.
So ISO is the International Organization for Standardization. They define standards for all sorts of management systems. For us in security, the big one is ISO 27000 Area 1.
The ISMS standard.
Yes, the standard for an Information Security Management System, or ISMS. It gives organizations a globally recognized, structured, and importantly, auditable way to manage their security requirements and demonstrate due diligence.
Okay, and then you mentioned COBIT. How does that fit in? Does it complement ISO?
It does, often. COBIT helps organizations tie that security structure, maybe defined by ISO 27001, back to the core business mission and objectives.
Connecting security to the business goals.
Precisely. COBIT stands for Control Objectives for Information and Related Technology. What makes frameworks like COBIT 5 or the newer COBIT 2019 so useful is that they provide a formal structure for IT governance and management, and it's organized around key domains.
Can you quickly walk us through those COBIT domains? How do they help demonstrate due diligence?
Sure. COBIT defines 5 core domains that really cover the full life cycle of IT governance and management. First is Evaluate, Direct, and Monitor, EDM. That's the governing body setting strategy and overseeing thing.
Okay, high level.
Then you have Align, Plan, and Organize, APO, which is where the high-level planning and structuring happens, very much aligns with due diligence.
Right.
Then the next 3 are more operational, leaning towards due care. You have Build, Acquire, and Implement, BAI, that's actually putting the controls and solutions in place.
Getting it done.
Then Deliver, Service, and Support, DSS. That's the day-to-day running of the services, the operations.
Keeping the lights on.
Exactly. And finally, Monitor, Evaluate, and Assess, MEA. This is crucial. It's how you measure performance, monitor conformity, and prove that due care is actually being performed effectively.
So the whole COBIT structure helps ensure security controls aren't just technical things, but they're actively mapped to business objectives.
That's the key benefit. It helps demonstrate that security is a strategic business enabler, maybe even an asset, not just viewed as an IT cost center or a necessary evil. It aligns everything.
All right, shifting gears a bit. As a cybersecurity consultant like Harshdeep, you're almost certainly dealing with data protection every single day.
Oh, constantly.
And the legal mandates around data are, like you said earlier, the tangible things that dictate our encryption methods, our access controls, our logging standards.
Right. That's a great way to put it. They have very real technical consequences. And it really all starts with defining the sensitive data itself. Globally, this conversation centers on personally identifiable information, or PII. Hashtag Hack 2.1, defining sensitive data and its classification.
Okay, PII. We hear that term all the time. But what's the sort of official definition we should be working with rather than just a casual understanding?
That's important. The formal definition of PII is typically any information that is linked or is linkable to an identifiable individual.
So it's broader than just name and address.
Much broader. It definitely includes things like medical records, educational information, financial details, employment history, anything that could potentially identify someone either on its own or when combined with other information.
And protecting PII is the main driver for privacy laws.
It is. The protection of PII is the fundamental driver behind pretty much all worldwide privacy requirements and legislation. If you're handling PII, you are automatically under the domain of serious legal requirements, period.
And in the U.S., specifically within healthcare, we have that extra layer, right? Protected health information, PHI, under HIPAA.
Absolutely. PHI is a specific category of PII related to health status, provision of healthcare or payment for healthcare, and it's treated with exceptional caution in the U.S. due to its sensitivity and the specific HIPAA regulations.
Okay, so beyond just the legal definitions like PII or PHI, organizations need to classify all their data, right? based on potential harm.
Yes, that's a critical component of due diligence. You need a data classification scheme. This usually involves assessing the potential damage if the data were disclosed inappropriately and assigning a classification level based on that impact.
And that classification then dictates the minimum level of security controls needed.
Exactly. It determines the baseline protection required. Let's quickly review those standard 4 classification levels. Pay attention to the escalating language about damage, because that's the legal trigger for the controls.
Okay, level 0.
Starting at the bottom, we have Class 0. This is usually called unclassified or public data. If this information gets revealed, our sources are clear, no damage occurs, so minimal or maybe even no specific security controls are required beyond general availability.
Makes sense. What's Class 1?
Then we move to the first level that actually requires protective controls. That's Class 1, often corresponding to labels like confidential or sensitive data.
Okay.
If this data is unintentionally or intentionally disclosed without authorization, the key phrase is it could cause damage to the organization, maybe a financial hit, loss of reputation, some kind of negative consequence.
So some damage, but maybe not catastrophic.
Right, that comes next. Class 2 is typically labeled secret or private data. Here, the potential damage level jumps significantly. Disclosure of Class 2 data can cause serious damage.
Serious damage. Like what?
Think major regulatory fines, perhaps significant competitive disadvantage if strategic plans leak, serious reputational harm. It's a major impact.
And the highest level, the most sensitive.
That is Class 3. Labels here might be top secret or sometimes confidential proprietary, depending on the scheme. Disclosure in this category is reserved for data where revelation can cause exceptionally grave damage.
Exceptionally grave damage, wow.
Yeah. This often includes things like critical trade secrets, national security information, or perhaps the most sensitive types of customer or patient data where disclosure could lead to identity theft or serious harm.
That escalating legal language damage,
Yeah.
serious damage, exceptionally grave damage, that's what justifies the increasing strength of the controls, like deciding between basic access control versus AES 256 encryption versus maybe even physical destruction.
Precisely. The classification level, driven by potential impact, dictates the necessary security investment and control rigor. It's a direct link. Hashtag tag 2.2, deep dive into GDPR terminology and requirements.
Okay, now let's dive into probably the most talked about regulation globally. The General Data Protection Regulation, or GDPR.
Ah, yes, GDPR.
For a consultant like Harshdeep, working with any client that touches EU data, even indirectly, the specific terminology and mandates of GDPR must be second nature, right?
Absolutely essential. It's highly likely to appear on certification exams, but more importantly, it's fundamental to real-world consulting. If you're dealing with the personal data of anyone in the EU, GDPR applies. And the key players you need to understand are the data controller and the data processor.
Okay, let's start with the controller. Who is that?
The data controller is the entity, could be a company, an organization, a public body that determines the purposes and means of the processing of personal data.
So they're the ones making the big decisions. Why collect the data? How will it be used?
Exactly. They are in charge. And because they make those decisions, they bear the primary responsibility for ensuring compliance with GDPR.
Okay. And the data processor, how are they different?
The data processor is a separate entity. It could be a person, a cloud provider like AWS or Azure, an agency, or some other body that processes personal data on behalf of the data controller.
Ah, so they're acting under instructions from the controller.
Correct. And this distinction is really critical. If Harshdeep's client is acting solely as a data processor, their contract with the controller must explicitly define the controls they need to implement. This helps define and potentially limit their liability as the controller ultimately remains responsible.
Makes sense.
Yeah.
Now, the technical demands of GDPR seem huge. It mandates things like consent needing to be freely given, specific, informed, and unambiguous. That must impact every web form, every click-wrap agreement out there.
It does. Consent management became a major focus. But beyond that, the requirements around respecting individuals' rights over their data have massive technical implications.
Like the right to erasure, the right to be forgotten.
Ah, yes, the right to erasure. That's where the real fun starts for technical teams. This isn't just about hitting delete on a record in a live database. No, it means you must be able to prove that the individual's personal data has been removed from all processing environments. That includes backups, archives, logs, anywhere it might exist.
Wow, all of them.
Within a specified, reasonable time frame, usually 1 month. This forces consultants and architects to design systems with granular, time-bound retention policies right from the start.
And it might necessitate complex key management if data is encrypted.
Absolutely. If you've encrypted data and thrown away the key, maybe that works. But if you need to selectively delete data from encrypted backups, that requires careful planning. It essentially forces data lifecycle management to be a core design principle, not just an operational afterthought.
So GDPR literally dictates backup strategy and recovery testing procedures.
In effect, yes. If a data subject requests erasure, and your backup tapes are kept for, say, 5 years with no practical way to reliably remove just their data set from those takes, you are likely in violation of GDPR.
Okay, what about planning for new projects? Does GDPR influence that?
It does, significantly.
Yeah.
GDPR mandates the use of a data protection impact assessment, DPIA, for any processing activities likely to result in a high risk to the rights and freedoms of individuals.
The DPIA. So that's like a risk assessment specifically for privacy.
That's exactly what it is. It's a formalized risk management process focused purely on data protection. It forces the controller, often with help from the processor, to proactively identify, assess, and then mitigate privacy risks before deploying a new system or process that uses PII in a high-risk way.
And for a consultant like Harshdeep, how should they use DPIA findings?
The key is to integrate the DPIA findings directly into the organization's overall risk registry and its security control baseline. Don't let it be a separate, standalone document.
Right, connected to the main risk management process.
Yes, this ensures that privacy risks are quantified, tracked, and addressed with specific technical and organizational controls, demonstrating that crucial due diligence before any potential harm occurs.
Makes sense. Now, one last GDPR point. The data transfer restrictions. These still seem to cause major headaches for multinational companies, especially those using public cloud.
Oh, they are a constant challenge. GDPR fundamentally restricts the transfer of personal data belonging to EU residents to countries outside the European Economic Area, EEA, unless specific, strict requirements are met. This usually means the receiving country must be deemed by the EU to have an adequate level of data protection, or there need to be specific legal safeguards in place.
Like SCCs,
Yeah.
standard contractual clauses.
Exactly. SECs are a common mechanism, or sometimes binding corporate rules, BCRs, for internal company transfers. But the bottom line is this directly forces organizations to make careful choices about their service providers.
Yeah, you have to know where your data is going and what legal protections are in place.
It impacts global network architecture, cloud provider selection, contract negotiations. It's a massive consideration for any international operation.
Okay, this next point sounds really important. There's a critical legal and technical distinction that apparently often trips people up. How we manage data exposure using anonymization versus pseudonymization.
Yes, this difference is paramount, especially when advising clients on data management strategies under GDPR. It can literally define whether GDPR applies to a specific data set or not.
Wow, okay. Let's start with anonymization. What does that mean precisely?
Anonymization is the definitive, ideally one-way process of removing or altering all relevant identifying data so that it becomes absolutely impossible to identify the original data subject.
Impossible even if you try to link it with other external data.
That's the goal of effective anonymization. The link is permanently broken. You cannot re-identify the individual.
And the big benefit here is,
If you anonymize data effectively, the resulting data set is generally no longer considered personal data under GDPR.
so GDPR simply doesn't apply anymore.
That's the key technical legal relief. If done correctly and thoroughly, GDPR is no longer relevant for that specific data set. The critical concept is that you intentionally and permanently destroy the link back to the individual.
So this is the way to go if you don't actually need the ability to re-identify the subject later on.
Exactly. If you just need aggregate statistics or trends and the individual identity is irrelevant moving forward, anonymization is often the safest route from a privacy compliance perspective.
Okay, that makes sense. Destroy the link, destroy the GDPR requirement for that data. But what if you do still need the underlying data for analysis?
Yeah.
Maybe behavioral analysis, statistical modeling, but you want to mask the identity from, say, the analysts using it.
That's the perfect scenario for the other technique, pseudonymization.
Okay, what's the difference?
Pseudonymization is the process of replacing identifying data fields with pseudonyms like aliases, tokens, or unique identifiers. You use this technique in scenarios where you still need the underlying information, the context, the behavior patterns, the detailed records.
Right.
But you want to mask the specific identity of the person involved from those who are accessing or processing the data operationally.
So the identity is masked, but crucially, the link still exists somewhere, right? It's stored securely elsewhere.
Yes, that's the fundamental difference. With pseudonymization, the link or the key needed to re-identify the data subject is maintained separately and must be protected by strong technical and organizational measures, things like strict access controls, encryption, segregation of duties.
And because that link still exists, because you can re-identify the person.
The data is still considered personal data under GDPR. The rules still apply.
Okay, so pseudonymization is really a security control to reduce risk, whereas anonymization is more like a legal relief strategy.
That's an excellent way to summarize it. Pseudonymization helps protect privacy during processing, but the data remains in scope for GDPR. True anonymization takes the data out of scope entirely, a very important distinction for any consultant like Harshdeep to explain clearly. Hashtag tag 2.4 U.S. federal privacy laws.
Okay, let's pivot back to the United States for a moment and cover two really critical federal privacy laws that come up all the time. First, HIPA, the Health Insurance Portability and Accountability Act.
Yes, HIPA, the absolute cornerstone of U.S. healthcare data security and privacy. It establishes the requirements for protecting that sensitive category we mentioned earlier, protected health information, or PHI.
But beyond the general protection requirements, what's the really operational piece that security teams need to focus on day to day?
From an operational and incident response perspective, the most critical part is arguably the high-tech breach notification rule, which amended HIPAA. This is where due care meets the hard realities of incident response planning.
Right. And that rule has very specific deadlines and reporting thresholds that security teams have to be ready to meet almost instantly after discovering a breach, doesn't it?
It does. Covered entities, healthcare providers, insurers, clearinghouses, and their business associates that experience a breach of unsecured PHI must notify the affected individuals without unreasonable delay, and crucially, in no case later than 60 calendar days after the discovery of the breach.
That 60-day window is a hard limit. You can't miss it.
It's a firm operational deadline. And discovery is defined quite broadly, often from when anyone in the workforce should reasonably have known.
And what about reporting to the government or the public? Are there specific thresholds for that?
Yes. If the breach affects 500 or more individuals, the covered entity has additional obligations. They must notify the Secretary of Health and Human Services, HHS, concurrently with notifying the individuals, so within that 60-day window.
Okay.
And significantly, they must also notify prominent media outlets serving the state or jurisdiction affected.
Notifying the media, that guarantees public attention.
Exactly. It ensures transparency, but obviously carries huge potential for reputational damage. Furthermore, even if a breach affects fewer than 500 people, the entity still has to maintain an internal log of such breaches and submit that log annually to the Secretary of HHS.
Wow. So even small breaches need meticulous tracking.
Absolutely. This demands extremely precise logging, incident classification, and documentation protocols within your incident response platform and procedures. You have to be ready to report accurately.
Okay, HIPAA high-tech is huge for healthcare.
Yep.
What's the other major federal law we need to touch on?
The other big one, especially relevant for online services, is COPPA.
COPPA, that's the Children's Privacy Law.
Yes, the Children's Online Privacy Protection Act of 1998. COPPA places very specific demands on operators of websites or online services that are directed towards children under 13, or operators who have actual knowledge that they are collecting personal information online from a child under 13.
Okay, so if your site targets kids or you know kids are using it, COPPA kicks in. What does it mandate?
It mandates several things. First, these websites must provide clear and comprehensive online privacy notices. They have to state exactly what information is collected from children, how it's used, and their disclosure practices.
Transparency is key.
Yes, but the really high bar, the major operational challenge, is around consent.
Parental consent, right.
Exactly. COPPA requires that these operators must obtain verifiable parental consent before collecting, using, or disclosing personal information from a child.
Verifiable consent. That sounds technically difficult. How do you verify it's actually the parent?
That's the massive technical hurdle. The FTC has approved various methods over the years, things like signed consent forms, calls with trained personnel, checking government ID, maybe processing a small monetary transaction. But it means security designers and developers must implement robust identity verification controls specifically designed to distinguish between an adult giving consent and a child potentially trying to bypass the system. It's a significant design consideration.
Okay, we've covered some fundamental laws and major global privacy drivers like GDPR. Now let's look at compliance more from the angle of specific industry mandates and also the inevitable legal life cycle of data itself. Where do we start here? Hashtag 3.1 Payment Card Industry Data Security Standard, PCI DSS.
We really have to begin with PCI DSS, the Payment Card Industry Data Security Standard. It is absolutely critical for anyone involved to understand its nature.
Okay, what's the key thing to know about its nature?
It is not a government law. Let's be very clear about that.
Right, not like IPA or GDPR.
No, it is a compulsory industry standard. It's created and enforced by the major payment card brands, Visa, MasterCard, American Express, Discover, JCB.
So the card companies enforce it.
They do. And if you, as a merchant or service provider, accept, process, store, or transmit cardholder data, then compliance with PCI DSS is effectively mandatory.
Why mandatory if it's not law? What's the stick?
The stick is significant penalties from the card brands, increased transaction fees, or ultimately the loss of your ability to process payment cards altogether. For many businesses, that's existential.
Okay, so it has real teeth, even without being legislation. And it's known for being very prescriptive.
Right? Extremely prescriptive. It's one of the most detailed security mandates globally. It lays out 12 core requirements which break down into hundreds of specific testing procedures.
So for a consultant like Harshdeep, what are some key requirements that directly drive technical configuration choices?
Oh, many of them. For example, requirement 3 is protect stored cardholder data. This often mandates using strong cryptography, maybe tokenization or truncation, so that the full primary account number, PN, is not stored unprotected after authorization.
Okay. No storing the raw card number if you don't absolutely have to.
Exactly. Requirement 4 mandates encrypting the transmission of cardholder data across open public networks, think TLS for websites. Requirement 5 demands up-to-date antivirus software or equivalent malware prevention measures on systems commonly affected.
What about logging? I hear that's a big one for PCI.
Oh, huge. Requirement 10 is often one of the most operationally challenging. Track and monitor all access to network resources and cardholder data.
That sounds broad. What does it mean in practice?
It necessitates robust, centralized logging systems. You need audit trails that link all access to system components and cardholder data back to an individual user. And crucially, it requires regular review of those logs, daily review, for logs from critical systems or security systems. For Harshdeep, this means accurately defining the scope of the cardholder data environment. CDE is step 1.
Right. What systems are actually in scope?
And then ensuring all systems within that defined CDE adhere to these strict logging, monitoring, and also vulnerability management standards outlined in Requirement 6, develop and maintain secure systems and applications, and Requirement 11, regularly test security systems and processes. It's comprehensive. Hashtag 3.2, the legal risk of data retention, and the need for destruction. All right, let's shift to another huge area of practical compliance and legal risk. Data retention. This is an area that is often ignored or poorly managed until a lawsuit hits.
Data retention, you mean how long organizations keep their data around?
Exactly. Many organizations historically have viewed data almost purely as a valuable asset. The tendency is often to just keep it indefinitely, just in case.
Yeah, storage is cheap. Why not keep it?
That thinking is a massive security and critically legal mistake.
Okay, why is keeping data longer than necessary so dangerous from a legal standpoint? What's the mechanism?
It's all governed by the need for a formal record retention policy. This policy is absolutely essential. Its purpose is to ensure data is kept only as long as necessary.
And what determines necessary?
That duration is determined by specific needs, statutory mandates, laws requiring retention for X years, regulatory requirements like SEC or HIPAA rules, or documented legitimate business needs. Anything beyond that time frame is potentially problematic.
And the danger comes during litigation.
Precisely. The danger crystallizes during the process of legal discovery, specifically e-discovery, electronic discovery. If a company gets sued, the opposing counsel can request access to relevant electronic records. And if the company has kept data longer than its own retention policy dictated or longer than legally required,
that extra data is now discoverable.
Yes, and it can absolutely be used against them in court. Our source material highlighted that critical aha moment anecdote, didn't it?
The aeronautical company.
Yes, that major aeronautical company. They ended up settling a large lawsuit for a much higher sum than perhaps necessary, specifically because they had retained historical data, emails, design documents, whatever it was that was well past its required retention period.
Yeah, and that old data which maybe seemed harmless at the time, ended up proving liability or increasing damages.
Exactly. The lesson is stark. Keeping data beyond its necessary lifespan is keeping unnecessary legal risk.
That story perfectly illustrates why secure data destruction isn't just a good housekeeping practice. It's actually a legal necessity driven by the retention policy.
It is absolutely a legal necessity. And this necessity directly drives the need for technical controls around end-of-life, EOL, planning for data and media.
So you need documented processes for getting rid of data securely.
Documented, verified processes are crucial for proving due care. This involves different methods depending on the sensitivity and media type. You have purging, which uses techniques like degaussing for magnetic media or cryptographic erasure.
Making the data truly unrecoverable.
It's unrecoverable using any known forensic techniques. Then there's clearing, which is less secure, basically overwriting data to prepare media for reuse in maybe a less secure environment within the organization.
Okay.
And finally, when the physical media itself is truly at its end of life, you need physical destruction, shredding hard drives, pulverizing SSDs, incineration.
And the key is following the policy.
Following the policy and documenting that you followed it. If your policy says, destroy financial records after 7 years, you must have proof that you demonstrably executed that destruction. Failure to do so, especially if litigation is anticipated or underway, could lead to serious legal trouble, potentially even a charge of spoliation of evidence. Hashtag tag 3.3, data sovereignty versus data localization.
Okay, let's tackle two more terms that sound quite similar, but apparently have critical, divergent legal and operational distinctions. This sounds particularly relevant for cloud computing contracts and vendor management. The terms are data sovereignty and data localization.
Yes, this is absolutely critical for consultants like Harshdeep, especially when advising clients on moving workloads to the cloud or dealing with global service providers. They sound related, but they address different aspects of data governance.
All right, let's define data localization first. You said that one's simpler.
Relatively simpler, yes. Data localization primarily addresses the geographical aspect of data storage and processing. Localization requirements are laws or policies that mandate that certain types of data must be stored and/or processed on servers that are physically located within specific geographical borders, usually a country or maybe a region like the EU.
Okay, so it's purely about the where. If a country passes a law saying all its citizens' tax records must physically reside on servers within that country, that's a data localization requirement.
That is pure data localization. It's about pinning the data to a map.
Okay, so how is data sovereignty different? It sounds grander.
It is broader. Data sovereignty is the much broader political and legal concept. It asserts that digital data is subject to the laws and regulations of the country or region where that data is located or potentially from which it originates or relates to.
Ah, so it's about which country's laws apply.
Exactly. It emphasizes a government's absolute authority and legal control over the data within its jurisdiction, regardless of where it might be physically stored sometimes. It's about legal power over the data.
Okay, give me an example to make that distinction clearer.
Sure. Imagine a US-based cloud provider stores data for a German company purely on servers located physically within Germany. That satisfies German data localization rules.
Right, the data is localized in Germany.
But if the U.S. government, under a U.S. law like the Cloud Act, compels that U.S.-based cloud provider to disclose that data, even though it's stored in Germany, that action relies on the principle of U.S. data sovereignty. The U.S. is asserting legal jurisdiction over the U.S. company, potentially requiring access to data regardless of its physical location.
Wow, okay, so sovereignty trumps localization in that scenario, potentially.
It can create significant conflict. Data sovereignty encompasses the legal authority aspect, while localization is just about the physical place. This distinction forces a consultant like Harshdeep to assess not just where the client's data will reside, localization, but also whose laws ultimately govern the service provider who has access to it, sovereignty.
Because the provider's nationality or legal home base matters hugely.
It matters hugely for the overall risk profile of any cloud migration or third-party data processing agreement. You have to understand both concepts.
All right, let's switch gears a bit now, moving away from personal data privacy and more towards protecting intangible assets, the company's own valuable information. Cybersecurity consultants are very often tasked with protecting an organization's most valuable assets, right? Their intellectual property, the stuff that gives them their competitive edge.
Yes, absolutely. And IP laws are specifically designed to provide legal protection for these intangible rights. But security plays a direct, critical, enabling role in making those legal protections effective.
How so?
Well, think about it. If we, as security professionals, fail in maintaining the confidentiality, integrity, or even availability of critical IP, the legal protection afforded by the IP laws can be significantly weakened or even rendered completely useless.
Ah, okay. If a trade secret leaks because of poor security, the legal protection might evaporate.
Precisely. Our controls are what make the legal rights enforceable in practice. Hashtag 4.1. The 4 types of intellectual property, IP protection.
Okay, so let's break down the 4 main types of IP protection, and maybe we can pivot immediately to the kinds of technical controls each one implicitly demands from us. Let's start with copyright.
Okay, copyright. This protects the expression of an idea, not the idea itself. It applies automatically to original works of authorship fixed in a tangible medium.
Like what kinds of works?
Literary works, musical compositions, dramatic works, visual arts, and very relevant for us, software source code is often protected by copyright.
Okay, and how long does copyright last? Is it forever?
Not forever, but a very long time. In the US, for works created by individuals, it typically lasts for the life of the author plus 70 years. For corporate works, it's different, but still very long.
Wow. Okay, so technically, what controls does protecting copyright demand?
It demands things like digital rights management, DRM systems for published content, strong access control lists, ACLs, on file servers where source code or manuscripts are stored, and maybe outbound data loss prevention, DLP systems, configured to recognize and potentially block copyrighted material from leaving the network without authorization.
Okay. Next type of IP, trademark. This is about branding.
Yes, trademarks protect brands. They are words, names, symbols, slogans, logos, anything used to identify and distinguish the goods or services of one party from those of others. The main legal objective is to prevent consumer confusion in the marketplace.
So protecting the Nike swoosh or the Coca-Cola script.
Exactly. The security challenge here is kind of twofold. First, protecting the integrity of the company's own digital trademarked assets, making sure the logo isn't altered on the website, for instance. And second, monitoring for fraudulent use of the trademark by others online. This involves things like proactive digital risk protection services, monitoring for cyber squatting, registering domain names similar to the trademark, and combating phishing sites that misuse the brand.
Okay. Then we get into protecting actual inventions and processes with patents.
Right. A patent grants property rights on an invention, allowing the patent holder to exclude others from making, using, or selling the invention for a set period, usually 20 years from the filing date. It protects novel processes, machines, manufacturers, compositions of matter.
Like a new way to manufacture a widget or a new chemical compound.
Exactly. Now, patents are interesting because to get the protection, the invention itself has to be publicly disclosed in the patent application. That's the trade-off.
Ah, so the secret's out once the patent is granted.
In a way, yes. So the security focus shifts slightly. It's less about keeping the final invention secret, once patented, and more about protecting the sensitive research and development, R&D data, leading up to the patent application. You need to protect the invention process itself from industrial espionage before you file.
Got it. And finally, the type of IP that seems to rely almost entirely on our security effectiveness day to day. The trade secret.
Ah, yes, the trade secret. This is information that companies keep secret to give them an edge over their competitors. It could be a formula, like the Coke formula.
It's a classic example.
Or a manufacturing process, a customer list, a complex algorithm, proprietary software components that aren't copyrighted or patented. The key is that it derives independent economic value from not being generally known, and the company takes reasonable measures to keep it secret.
And the legal protection lasts.
Potentially indefinitely, but only as long as it remains secret.
So the moment the secret is out, the legal protection can vanish.
Often, yes. If the information becomes public knowledge, even accidentally due to poor security, the trade secret protection is typically lost entirely.
Wow. That means the technical security controls are, in effect, the primary legal defense for a trade secret.
That's exactly right. This demands the absolute most stringent internal controls. Think zero trust network segmentation to limit access, strict need-to-know principles enforced through access control, robust physical security for labs or sensitive areas,
And insider threat.
huge focus on insider threat monitoring, plus comprehensive data loss prevention, DLP, specifically configured to detect and prevent sensitive proprietary blueprints, formulas, source code, or strategic plans from leaving the network perimeter, whether by email, USB drive, or cloud upload. The security is the protection. Hashtag 4.2, the Economic Espionage Act of 1996.
Given how critical trade secrets are and how dependent their protection is on security, it makes sense that Congress would take their theft very seriously.
Yeah.
You mentioned the Economic Espionage Act of 1996, the EEA.
Yes, the EEA underlines just how seriously the U.S. government views the theft of trade secrets, particularly when it benefits foreign entities. This law is exceptionally severe and clearly positions trade secret theft not just as a corporate problem, but as a threat to national economic security.
And it has specific provisions with heavy penalties.
It does. It has two main criminal provisions, Harshdeep, that you should be aware of. The first deals with theft intending to benefit a foreign government, instrumentality, or agent.
Okay, stealing for another country. What are the penalties for an individual caught doing that?
They are massive. If an individual is found guilty under this provision, they face a fine of up to $500,000 or imprisonment for up to 15 years, or both.
15 years for IP theft.
15 years in federal prison if it's proven they stole trade secrets intending to benefit a foreign power. That really underscores the severity.
And what about penalties for the organization involved if a company's found guilty of this?
If the organization itself is convicted under this provision, the fine can be up to $10 million. $10 million.
Wow. Okay, that puts into perspective why investing in robust DLP, insider threat detection, and stringent access controls isn't just best practice.
It's a critical legal defense mechanism against potentially crippling liability and, frankly, operational shutdown if key secrets are lost or massive fines are incurred. It's risk management at its core. Hashtag 4.3, the Computer Fraud and Abuse Act, CFAA.
Okay, let's circle back to direct cybercrime legislation for a moment with the Computer Fraud and Abuse Act, the CFAA. You mentioned it earlier under criminal law. It originally passed way back as part of the Comprehensive Crime Control Act of 1984, right?
That's right. The CFAA was really groundbreaking for its time. It was one of the first major laws specifically written to address computer crimes, particularly those that cross state boundaries or involve protected computers, which includes federal interest computers, financial institution computers, and computers used in interstate or foreign commerce or communication.
So it established federal jurisdiction over a wide range of computer misuse.
Exactly. Its intent was really to modernize the legal system to handle the emerging challenges of unauthorized access and computer misuse in the burgeoning digital age.
Now, the critical language in the CFAA often revolves around accessing a computer without authorization or exceeding authorized access. That sounds straightforward, but this language has also led to significant debate and criticism over the years, hasn't it?
It absolutely has. That phrasing, without authorization or exceeding authorized access, is the core of the conflict. The common criticism, often voiced by the security research community and civil liberties groups, is that the CFAA, as written and sometimes interpreted, is potentially overbroad.
Overbroad? How so?
Because of the somewhat ambiguous wording, some prosecutors and courts have, in the past, interpreted access without authorization to include actions that might simply violate a website's terms of service, TOS, or an employer's computer use policy.
Wait a minute. You're saying that just violating a website's fine print, its TOS, could theoretically be prosecuted as a federal crime under the CFAA?
That has been the controversial interpretation in some cases, yes. While recent court decisions, including from the Supreme Court, have pushed back against the most expansive interpretations relating purely to TOS violations after initial access was granted, the potential ambiguity remains a concern.
Why is this a concern for security professionals?
It makes security researchers, penetration testers, and consultants like Harshdeep potentially wary. An action that might be intended for legitimate, non-malicious vulnerability research or security testing, say, scraping publicly available data from a website in a way that technically violates its TOS, or probing a system slightly beyond the explicitly stated scope could, under an aggressive interpretation, be argued as exceeding authorized access.
Okay, so for Harshdeep, the consultant, what's the practical takeaway here? How do you navigate this?
Contracts and clear authorization are absolutely paramount. To protect yourself and your client, you must have explicit, unambiguous, written contractual authorization before conducting any kind of security testing or assessment on a system.
And that contract needs to be detailed.
It's very detailed. It needs to specify exactly what systems are in scope, what types of testing are permitted, what access methods are authorized, and for what purpose. This creates a clear record that your access was authorized, helping to avoid falling into that gray area that could potentially trigger a CFAA claim, however unlikely.
So the technical work is crucial, but the legal framework, the contract granting clear authorization, has to be secured first.
Precisely. Get it in writing, be specific, and stay within scope. That's the best defense against any legal ambiguity around authorization.
Okay, fantastic. We've covered the why, the legal landscape, the liability, and the what specific laws like GDPR, IPO, CFAA, IP protections.
Yeah.
Now let's try to tie this all directly to the how. How do these legal requirements actually influence the processes and documentation you use when implementing controls in the real world? Hashtag 5.1, integrating security controls with legal baselines.
This is where the rubber meets the road for implementation. Organizations, especially larger ones, rely heavily on formalized standards and frameworks to guide their control selection. A common approach is using resources like those from NIST, the National Institute of Standards and Technology, particularly NIST Special Publication 853.
Right. NIST SP 853 provides a huge catalog of security and privacy controls.
Exactly. Organizations use catalogs like this to create security control baselines. These baselines provide a standardized starting point, a recommended list of controls for systems based on their impact level: low, moderate, high. It's a way to ensure consistency and meet general compliance goals.
But a generic baseline, even from NIST, is rarely going to be a perfect fit for every single organization or system right out of the box, is it?
Almost never. It needs to be customized. It has to be adapted to fit the organization's unique mission, its specific operating environment, its risk tolerance, and crucially, the specific legal and regulatory mandates it falls under.
And how do organizations adapt these baselines? Are there standard processes for that?
Yes, there are two core techniques, and they are often confused, so it's good to clarify them: scoping and tailoring.
Okay, let's clarify scoping first. What does that involve?
Scoping is the process of determining which parts of the baseline are actually applicable to the specific system or environment you're looking at. You're essentially limiting the scope of application.
Can you give an example?
Sure. Imagine a NIST baseline includes controls for securing external network connections. If you're applying this baseline to a completely isolated internal-only payroll server that has zero external connectivity, you would use scoping to determine that those specific external connection controls are not applicable to that particular server. You're limiting the universe of systems to which those specific controls apply.
Okay, so scoping is about applicability. Does this control even apply here? What about tailoring then?
Tailoring is the next step. Once you've scoped the applicable controls, tailoring involves modifying the baseline list itself. This means you might remove certain controls from the list if they aren't deemed necessary or cost-effective for the organization's specific mission or risk environment, perhaps accepting the risk formally.
So you can remove controls.
You can, with justification and formal risk acceptance. But tailoring also, very importantly, involves adding controls.
Adding controls not in the original baseline.
Yes, you might need to add controls required by specific laws, regulations, or industry standards that weren't covered in the generic baseline you started with. Or you might need to enhance existing baseline controls, making them more stringent to meet a specific legal requirement.
Can you give a specific example of tailoring driven by a legal mandate, like we discussed earlier?
Absolutely. Think back to HIPAA. The generic encryption control in NIST SP 853 might just say, use validated cryptography.
Okay, fairly general.
But if your client is a healthcare provider handling PHI, you must tailor that control. You'd specify meeting the explicit encryption standards, like AES, key management requirements, and maybe the specific implementation guidance referenced by HHS for IPA compliance.
Making it much more specific to meet the law.
Exactly. Or if you operate in California, you might tailor in additional privacy controls to satisfy specific requirements of the CCPA or CPRA that go above and beyond a federal baseline. Tailoring ensures the final control list perfectly matches your organization's unique operational environment and its specific legal and compliance mandate. It makes the baseline truly fit for purpose. Hashtag 5.2 third-party and vendor contractual obligations.
That makes sense for internal systems, but so much business today involves external entities, cloud providers, SaaS vendors, contractors, joint venture partners. How is legal risk managed in those relationships? It seems like contracts would be key.
Contracts are absolutely fundamental. When dealing with third parties, legal risk is primarily managed or mitigated through carefully constructed contractual documents. The foundation for operational expectations is usually the service level agreement, or SLA.
SLAs. We hear about those all the time, especially with cloud services. What's their core legal function?
SLAs are the formal mechanism for defining clear, measurable expectations for performance and availability between a service provider and a customer. They define specific metrics, things like system uptime percentage, network throughput, help desk response times, maybe disaster recovery time objectives, RTOs.
Okay, setting the performance bar.
Yes. But their real legal teeth come from the specified financial and contractual remedies that automatically kick in if those agreed upon expectations are not met.
Ah, the penalties.
Exactly. If the service uptime drops below the guaranteed 99.9%, the SLA should dictate the exact service credit, refund, or other remedy the customer is entitled to receive. It provides a predefined recourse for performance failures.
Okay, so SLAs cover performance and availability. But what about when we need to actually connect our network directly to a third party's network? That seems like a higher security risk that needs more specific agreement.
It absolutely is. When you're establishing direct network-to-network connectivity, SLAs aren't enough. You need a document focused purely on the security implications of that interconnection. That's the essential Interconnection Security Agreement, ISA.
ISA. Okay, what does that cover?
An ISA is necessary for formally documenting the agreement between two organizations on the security requirements for connecting their separate IT infrastructures. It defines things like the agreed-upon security posture for both sides, identifies the shared risks involved in the connection, and establishes the minimum technical requirements.
Like what kind of technical requirements?
For example, before linking your corporate VPN to a dedicated network segment provided by a cloud partner, the ISA would define things like mutual patching standards for the interconnected systems, incident notification procedures and escalation contacts, maybe acceptable encryption ciphers for the VPN tunnel, and who is responsible for monitoring what.
And why is having a formal ISA considered a legal necessity, or at least a critical part of due diligence?
Because it demonstrates due diligence in managing third-party connection risk. It provides documented evidence that both organizations formally considered the security implications and agreed upon the necessary controls to protect that shared communication channel.
So if a breach occurs through that link.
Having a well-defined ISA helps demonstrate that you took reasonable, prudent steps to secure it, which can significantly minimize liability. Without an ISA, proving due care in managing the security of a shared environment becomes extremely difficult, if not impossible. It's a critical governance document for interconnected systems. #tag 5.3 auditing as proof of due care.
Okay, we established earlier that due care is the ongoing action that prevents negligence. We need proof that this action is happening effectively. That sounds like where auditing comes in. Security audits are the official, documented proof that due care is being performed consistently, right?
That's exactly their role in the governance framework. Auditing, along with regular effectiveness reviews and continuous monitoring, are the key elements in demonstrating prudent action and fulfilling the due care obligation.
And without that proof.
If a major incident or breach occurs and senior management cannot produce recent, credible audit documentation showing that controls were in place and operating effectively, they face a very high risk of being held liable for negligence. Audits provide that crucial evidence of diligence and care.
Now, we generally see two main types of audits conducted in organizations. First, there are internal audits. What's their primary purpose?
Internal audits are performed proactively, usually by the organization's own dedicated internal audit staff, or sometimes by designated teams within IT or security. Their purpose is primarily about readiness and internal assurance.
Readiness for what?
Readiness for upcoming external audits, for one. They help ensure the organization is prepared before the third-party auditors arrive. They also serve to confirm the ongoing effectiveness of internal controls, identify gaps, and provide management with assurance that processes are working as intended. Think of it as an operational checkup on due care performance.
Okay. And then the other type, the one that often carries more external weight, is the third party or external audit.
Yes, these are independent evaluations. They are performed by accredited, qualified auditors who are not affiliated with the organization being audited. This independence and impartiality are key.
Why is independence so important?
Because it ensures an unbiased, objective evaluation of the organization's controls against a specific standard or framework like PDI DSS, SOC2 criteria, ISO 27001, or specific regulatory requirements. This unbiased assessment carries immense legal and business weight in proving due care and demonstrating adherence to compliance mandates to customers, partners, and regulators.
So as a general rule for consultants like Harshdeep, when they hear the term audit, Should they assume it's external unless specified otherwise?
That's a very safe assumption in most contexts. Unless it's explicitly called an internal audit or a self-assessment, the term audit in a compliance or legal context usually implies a formal, independent, third-party audit, as that's the standard for external verification.
Okay. Now, there's a final, really vital point about auditing that Harshdeep needs to consider. What happens with the audit report itself? It seems like that document could be incredibly sensitive.
Oh, absolutely critical. You must have strict processes for controlling audit reports. These documents are, in essence, a high-level, expert-validated roadmap of your organization's security posture, including its weaknesses.
What kind of sensitive information is in them?
They typically contain highly sensitive findings, the exact scope of the audit, what was tested, detailed descriptions of any identified control deficiencies or vulnerabilities, and concrete recommendations for remediation.
So basically, a blueprint for an attacker if it fell into the wrong hands.
Precisely. If this sensitive information were to be disclosed to a malicious entity, the potential damage could easily fall into that Class 3 category we discussed earlier, exceptionally grave damage. Audit reports themselves must be classified and protected as highly confidential assets.
How should they be protected?
Often with encryption at rest and end transit, strict need-to-know access controls, only distributed to those directly involved in remediation or oversight, secure storage, and potentially even non-disclosure agreements for the auditors themselves. Protecting the audit report is just as important as fixing the findings within it. So, Harshdeep, if we try to bring everything we've discussed today together, what we really want you to see is that these laws and regulations, they're not just some abstract nuisance that we have to deal with on the side.
Yeah, they're not just paperwork.
Not at all. They are tangible, powerful drivers of almost every technical security decision we make.
Compliance dictates specific encryption levels for PHI under IPT, like you said. It forces us to implement time-bound policies for secure data destruction to prevent that kind of accidental legal liability we saw in the aeronautical company anecdote.
Exactly. And it demands specific documented processes for complex issues like data transfer restrictions under GDPR. Your deep understanding of these legal frameworks isn't just academic. It translates directly into tangible risk reduction and demonstrably prudent management that's due care for your clients or your own organization.
It really elevates the role of security consulting beyond just technical implementation. It's strategic risk management informed by law.
That's the highest form of strategic consulting, absolutely. And that's really the true value we hope you get from this deep dive.
Okay, now as we wrap up, let's leave you with one final provocative thought. Something that demonstrates that inherent, sometimes difficult tension, where legal mandates and pure technical security ideology might collide.
Yes. We talked quite a bit about encryption and managing keys, where the focus in security circles is often purely on maximizing strength and confidentiality, minimizing access.
Right. Keep the keys safe, limit who can touch them.
But the source material we reviewed also touches on a concept called key escrow.
Key escrow. What is that exactly?
Key escrow is a practice where a copy of a cryptographic key, or components needed to reconstruct it, is stored securely with a trusted third party or possibly split among multiple trusted third parties.
Okay, why would anyone do that? Technically, that sounds like it introduces more risk, more points of failure, potentially giving access to parties beyond the core administrators. Security purists often frown on it.
They often do, for exactly those reasons. But key escrow is typically done for a specific, often legally driven purpose. One reason might be to ensure authorized user access can be restored if the original key is lost, a form of recovery.
Okay, that makes some sense. Business continuity.
But perhaps the more controversial application, and this is where the conflict arises, is potentially for legal access.
Meaning access by law enforcement or government agencies.
Potentially, yes.
Yeah.
Under specific circumstances, like a valid court order or other lawful administrative mandate, an escrow arrangement could provide a technical mechanism for a government entity to gain access to encrypted data. It creates a technical pathway to satisfy a potential legal requirement for access.
And that creates a direct conflict, doesn't it?
It absolutely does. And this raises a critical, fundamental question for any cybersecurity consultant like you, Harshdeep, who is designing secure systems, especially for global organizations dealing with different legal regimes.
The question being,
when does the legitimate legal requirement for access or recovery driven by law or business need directly conflict with the pure security goal of absolute confidentiality and minimizing trust? And more importantly, how do we as architects and consultants design robust cryptographic systems that attempt to satisfy both mandates?
How do you build a system that allows for legally mandated access under strict controls, while still providing sufficient cryptographic protection against unauthorized parties or abuse of that access mechanism?
Exactly. This inherent conflict between the confidentiality ideal and the practical, sometimes legal necessity of controlled, lawful access is perhaps one of the most significant and complex design challenges you will face when architecting secure systems in the real world.
That is a massive philosophical and technical challenge to mull over. How do you balance security purity with legal reality?
It's something to constantly consider as you build out secure architectures for clients operating under diverse and evolving legal landscapes.
Food for thought indeed. That definitely wraps up this specialized deep dive into the critical intersection of information security laws and compliance. We hope this was valuable for you. Until next time.
Stay secure, stay compliant, and keep learning.